victims of violence against women. And we thank you for taking your time to join us. I'd like to now invite my colleague Winnie to take over and just take us through this conversation. Thank you.
Thanks, Aching, and welcome everyone. Good afternoon and welcome to this webinar. This webinar is being hosted by the Initiative for Strategic Litigation in Africa, and it is a webinar on out-of-court settlement agreements for violence against women cases in Kenya. My name is Winfred Odali. I work at ISLA as an associate lawyer, and I'm going to be your moderator for this session. So I'll proceed to introduce our panelists for the day. And our panel is quite a rich panel consisting of 4 very distinguished ladies. We have Honorable Lady Justice Njoki Ndung'u, who is, I believe, is not here yet, but she will be joining us shortly. We also have Ms. Nicolette Naylor, we have Ms. Christine Alai, and we have Dr. Ruth Nekura. So I'm going to read out their bios just briefly so that you get to understand who our panelists are. So I'll start with Honorable Lady Justice Njoki Ndung'u. Honorable Njoki Ndung'u is a judge of the Supreme Court of Kenya. She is the chairperson of the Judiciary Employee Protection and Integrity Committee and a member of the Judiciary Leadership Team. She holds the Supreme Court Governance and Regulatory Affairs portfolio, heading both the Rules and Publications Committees of the court. Prior to her appointment, she sat on the Committee of Experts on Constitutional Review that drafted the current Constitution of Kenya. And she also served as a member of the National Assembly of the 9th Parliament and the Pan-African Parliament between 2003 and 2007. Most notably, she was the mover of the Sexual Offences Bill 2006, which later became the Sexual Offences Act, and was also the mover of key amendments for legislative change, including those on maternity and paternity leave. She also served in various other capacities internationally and nationally, including as State Counsel at the Office of the Attorney General, National Protection Officer at the United Nations High Commissioner for Refugees, Women in Law and Development, and also as political analyst for the African Union. She was awarded the UN Person of the Year and ICJ Kenya Jurist of the Year Award in 2006, and she was also awarded national honors, including the Elder of the Order of Burning Spear and the Chief of the Order of the Burning Spear. So that is Honorable Njoki Ndung'u. She'll be joining us shortly. Then next, I'm going to move to Ms. Nicolette Naylor. Ms. Nicolette is a senior philanthropy executive who has spent more than 2 decades working in the intersection of justice, feminism, and philanthropy. She is the CEO and founder of Ubuntu Global Philanthropy and Gender Justice Consulting, which is an organization providing support to philanthropy organizations, civil society organizations, and academic institutions. Prior to 2023, Nicolette spent 16 years at the Ford Foundation, where she led the Southern Africa office and the International Program on Gender, Racial, and Ethnic Justice. Nicolette is an international human rights lawyer by training and spent the early part of her career litigating human rights cases in South Africa, before the African Commission, and also before the European Court of Human Rights. She holds an LLM in International Human Rights Law from the University College of London and a Bachelor in Procurement, as well as an LLB from the University of Western Cape. Welcome, Nicolette. We are happy to have you here. And next, I'm going to introduce Ms. Christine Alai. Ms. Christine Alai, also known as Tina Alai. She's a human rights lawyer who has dedicated her 18 years career to championing for equality, non-discrimination, and access to justice for victims of gross human rights violations and atrocity crimes. Ms. Alai has led and contributed to innovative litigation, research, policy, and legislative developments and advocacy initiatives to advance human rights and transitional justice in Kenya, South Sudan, and parts of East and Central Africa. Ms. Alai has specialized expertise on advancing survivor-centered prevention and response to sexual and gender-based violence, especially in conflict and emergency situations. Notably, Ms. Alai has been at the forefront of strategic impact litigation seeking state accountability and reparations for survivors of sexual violence committed in the context of political and election-related violence in Kenya. Ms. Alai is a co-founder of Utu Trust, which is a budding think tank that focuses on enhancing gender justice. Utu Trust is also one of the partner organizations that ISLA is partnering with under the Feminist Litigation Network. Ms. Alai also serves as the Transitional Justice Advisor to the UN Commission and on Human Rights in South Sudan. Karibu sana, Ms. Alai, you're welcome. Last but definitely not least, we have Dr. Ruth Nekura, who is not a stranger to these ISLA conversations. Dr. Ruth is a feminist lawyer and a social legal researcher with 14 years experience working on human rights and gender equality with a focus on law and policy reform, program design, implementation and evaluation, strategic litigation, advocacy, and knowledge leadership. She's an advocate of the High Court of Kenya and holds an LLM and a PhD in public international law, specializing in human rights from the University of Cape Town. She enjoys teaching and research, and she works as an independent consultant, providing technical support to civil society organizations. She has also worked variously with a diverse cross-section of actors, including grassroots activists, national and international organizations. Those are our panelists for the day. Karibu sana, Dr. Ruth Nekura, together with all our panelists for the day, and feel at home. So I'll move on and just explain what ISLA does. ISLA has 4 priority areas, and one of the priority areas is litigation for social change. Now, the objective of the litigation for social change priority area is to develop jurisprudence through the courts to hold state and non-state actors accountable for human rights violation based on gender and sexualities. Under this priority area, ISLA has various thematic areas, and one of these thematic areas is violence against women. ISLA, under this thematic area, has taken up a series of cases that we call the state due diligence obligation cases. So these are cases that seek to hold the state accountable in their due diligence obligations towards victims of violence against women. And this is by preventing, protecting, investigating, prosecuting, punishing, and providing remedies for violence against women. One of the cases that we have taken up and we have actually gotten judgment under this series of cases is the case of IW and Crew versus the Attorney General and others. So this is a case that was before the High Court Constitutional Division of Kenya, and the judgment was delivered on the 15th of December, 2023. So this case involved, just the brief facts of this case, it involved a university student who at the height of the COVID pandemic had to seek employment. And this is because for those who live in Kenya, you know that at that time schools had been shut indefinitely, and therefore she had to seek employment. And she sought employment as a sales marketer, and it so happened that the employer was an ex-police officer. And this ex-police officer raped her in the course of her employment. So she reported the matter to the police, and the investigating officer, upon realizing that the perpetrator was an ex-police officer, coerced her to entering into an out-of-court settlement agreement with the perpetrator just so that the matter does not get to court. So after this happened, she sought justice through the Constitutional Court against the police. And on the 15th of December 2023, the court issued its judgment declaring out-of-court settlements for violence against women cases unconstitutional, and also declared that these out-of-court settlements should not be entered into by the police or otherwise, except under the direction of the Director of Public Prosecutions and while acting within the Constitution. So these are the brief facts of the case and briefly just what the judgment touched on. However, it's also important to note that in this case, the court held that the petitioners had not produced sufficient evidence proving the existence of an actual out-of-court agreement, and so the rest of the orders were denied. So those are the brief facts of the case. I can see we have been joined by Honorable Justice Njoki Ndung'u. Karibu sana. We are happy to have you on board. And we have already introduced you to the audience. So welcome, we're happy to have you. So I'll proceed to the first question. And our first question goes to Ms. Tina Alai. Having read the judgment, do you think it adopts a human rights approach? And as you are telling us about that, maybe you could also just explain to us, why is it so important for the court to find that out-of-court settlements for violence against women are unconstitutional? Ms. Alai.
Thank you very much, Winnie. Good afternoon to our audience. Good afternoon, Honorable Justice Njoki, and to my fellow panelists. Thank you, Isla, for organizing this very important consultative engagement. And I would say an emphatic yes, this is a very important determination by the Constitutional Court of Kenya. And I think it's very much human rights centered because the judgment is premised on the provision of the Constitution, particularly in the Bill of Rights, Articles 27, 28, 29, which obligate the state to put in place effective measures for prevention and response to sexual and gender-based violence in Kenya. And part of that obligation requires that the state would put in place effective measures for reporting of these violations, for investigations of the violations, and for prosecutions. And it builds also on the substantive law that has been enacted to give effect to these articles in the Bill of Rights, and particularly the Sexual Offences Act, which spells out specific offenses, sexual violence crimes, but also spells out specific penalties that correspond to those offenses, for which the state is obligated to ensure that there's proper investigations and prosecution. But finally, just to mention that whereas the law has existed, the Sexual Offences Act, for instance, has existed since 2006, we've had several iterations of guidelines that articulate specific roles and responsibilities for different actors within the health sector, the police, judicial sector, psychosocial support, and so on. We have seen significant challenges along this pathway that have required continuous affirmation by the courts. And in this particular instance, we have seen studies, data, reports on a daily basis of interference with investigations and prosecutions, kangaroo courts being set up within the community, unlawful out-of-court settlements. And I think this case, therefore, comes in to set a very important precedent, affirming the state's obligation to ensure that it takes all effective measures to prevent this kind of interference, whether it comes from the community or by duty bearers in the like of police officers, such as what we have seen in this case. And I believe as we will continue with the engagements during this consultation, we'll also see that this case then also opens a door. It provides a space where we can begin to articulate clearly how do we apply the principles of alternative dispute resolution and alternative justice systems to serious offenses such as sexual violence and sexual and gender-based violence. To what extent are they applicable? Because it appears just from reading the judgment, but also looking up our policies, we still have quite some room to go to articulate in writing and in practice how we then bring to life this judgment that declares unconstitutional out-of-court settlements for sexual offenses. I thank you.
Thank you very much, Ms. Tina, for that. Just setting for us the context behind what we're talking about today. And I want to move on now to Honorable Lady Justice Njoki Ndung'u. We know that Article 159 of the Constitution of Kenya envisions the alternative justice systems as a preferable means to reduce the burden on the judicial system, and actually encourages parties to pursue alternative justice systems. So, Honorable Judge, you were the mover of the Sexual Offences Bill, which later became the Sexual Offences Act. From your point of view, why do you think sexual offences were distinguished from other offences and excluded from this provision of pursuing alternative justice systems?
That's an interesting question, but let me just take you back to the history of the Sexual Offences Act. And if I can draw your attention to Section 40 of the the Sexual Offences Act, which says that the decision as to whether a prosecution of a complaint in respect of a sexual offense can only be discontinued with the approval of the Director of Public Prosecutions. And the reason that that provision was put in the Act is because for many, many years, ADR actually was the way that communities went, and victims were not actually getting justice. It would be their families negotiating, but the rights of the victims were not recognized. So either the matter did not reach the police station at all, or if it reached the police station, then the negotiations would happen at the police station. And through this section, what we had intended was that the matter has to reach the courts. And it's only the DPP, not even the police officers can discontinue. There was a lot of corruption as well. Perpetrators giving money to police officers, and that would be the end of the case. So I think in terms of the nature of a criminal law, I myself, as the architect of the Sexual Offences Bill, which became the Act, I was very clear that there ought to be no negotiations where you have an act, a felony, a crime that has been committed against a person. Furthermore, I still think, and this is that's why I decided to join this webinar. I found it a very interesting approach, because my thinking has always been that ADR agreements in sexual offenses will infringe on the provisions of international instruments to which Kenya is a party, because I think it's important that we use the formal justice system. I believe it ensures better due process, better victim protection, and also consistent legal outcomes when you go to the court. Currently, the judiciary is conducting ADR, which means we're reaching out to communities in order to resolve disputes, because 70% of the disputes in Kenya don't actually come to the courts. But we have declined to include sexual offenses. We've excluded it from the ADR under Article 159, because I think first we need to recognize that sex crimes are grave violations. It goes beyond civil disputes, and it requires formal legal processes. Secondly, when you do an ADR, you have to ground it on the agency test. That the parties come to consent, there's no prejudice against either of the parties. And cases like defilement, rape of children, it'll fail the agency test because it involves minors whose capacity to negotiate and enter into an out-of-court settlement they don't have that. You can't meet the agency test in those kind of cases. So I found this case that you presented to us interesting, but it is not a criminal case. It's very interesting that it was a matter of constitutional interpretation, which did not go to the criminal courts. It was not approached as a criminal matter. It was approached in terms of almost a civil or a civil litigation basis, and therefore I found it very interesting. I'm not sure whether this method can be encouraged. Looking through the proceedings, I had to wonder whether or not the petitioner did not feel coerced into going into the negotiated process, or if it was her choice to go into the negotiations. So it's not clear to me. And sometimes I wonder whether would we have a negotiated process or ADR for other felonies like murder or robbery with violence? So I think it's an area of concern. Like I said, it's interesting that it's a matter that you've brought to bear. And I guess if all parties feel that they are sufficiently compensated and that it is just, perhaps it's a way to go, but I can see so many pitfalls. I see so many problems with that approach. But let me say that for now. Thank you.
Thank you so much, Honorable Judge, for just sharing with us, especially the history of how the Sexual Offences Act came into place and what informed Section 40 of the Sexual Offences Act, as well as just talking about the current case and the pitfalls that we are seeing along the way. So let me move on to Ms. Nicolette. And as we've been talking about the Sexual Offences Act of Kenya, this act actually stipulates minimum sentences for sexual offences, as opposed to giving options for out-of-court settlement agreements. So I just want to hear from you what you think about this carceral approach to punishment of sexual violence. How does a carceral approach to punishment guarantee a safer world for victims of sexual violence? And as you're talking about that, perhaps you can also just talk to us about the international human rights standards that provide the standards on appropriate remedies for sexual violence.
Thank you. And thank you, Isla, for having me here today. I think, like the Honorable Judge has just mentioned around out-of-court settlements, the potential for it to be harmful, I think we need to hold that at one level. We also need to recognize that in a lot of jurisdictions, prosecutorial guidelines have come about around serious offenses, that you can't submit rape, armed robbery, murder to ADR processes, mediation processes. You have civil remedies and there's the criminal process. But notwithstanding that, on the ground, at lower court level and at police level, you do have this, the system is subject to abuse, and you do have this happening where people are entering into these out-of-court settlements. And so how do we hold that with the survivor-centered approach in terms of wanting to be trauma-informed and recognize that survivors are not monolithic, and some survivors don't want to enter the criminal justice system, want to go the civil route, or don't want to go either of those routes. And so I think there's a tension there. On the carceral system, and I think we, as feminist lawyers, we critique the criminal justice system, but we also work to improve the criminal justice system. And for a long time, and so I have a critique of the criminal justice system because it does have the potential to disempower survivors and silence survivors and render survivors invisible. But I do think it's a very important element in terms of accountability and justice that we have to rely on and use the criminal justice system as a form of justice and accountability, but it needs to be one form of justice alongside other forms of justice, and what that justice looks like, what it feels like, has to be really informed by survivors. The other point, I think, is that where the criminal law has evolved, and I think historically, you've seen the criminal law as really this rendering survivors invisible, as really, you know, it's all about the accused and the survivors just a side player to the legal drama that's playing out between the accused and the state. We have a number of legal instruments, international frameworks now that have recognized that the criminal justice system has rendered survivors invisible, and is now aimed to really address secondary victimization, to address the historic invisibility of survivors, and provide protection for survivors through specialized courts, through legislation like the Sexual Offences Act in Kenya, in South Africa. And we have the framework that's been established, the due diligence framework in international law. We've got the Maputo Protocol, we've got General Recommendation 19 that has unpacked all of that, and we've got case law that does provide specific protections. And so I would say, despite the flaws within the criminal justice system, we do have to recognize that it is a tool to provide more effective protection for survivors. And I think the way the Maputo Protocol speaks of punishing perpetrators of violence and establishing accessible services for and remedies and reparation for victims is important, and how we interpret what reparation looks like and what justice looks like is important. A lot of the international frameworks have really spoken about what does effective remedies look like, and effective remedies have touched on the criminal, the carceral approach, as well as the civil remedies. I have issues around out-of-court settlements, mediation processes, and ADR processes that are not acknowledging and are not being handled by sexual offences experts and specialists, that are not taking into account power dynamics, because this isn't an ADR process where you're dealing with the return of something that was stolen or a divorce. This is actually a crime that's grounded in coercion and power. And so how do you actually address that in these processes? And you could probably do processes like this if you had the necessary expertise and skills to address things like secondary victimization, power dynamics, and to make sure that it's free of coercion. And I think a lot of the international case law, the case in Kenya at the moment, every court case that we've seen has really spoken about the duty to investigate and prosecute and punish and provide remedies must always be free of coercion. It must be effective. It must, you know, so all those principles that we're starting to hear, how do we apply those principles and really test and interrogate what processes look like outside of the criminal justice system? Let me stop there for now.
Thank you. Thank you so much, Ms. Nicolette, for that. Now, Dr. Ruth, we have the CEDAW General Recommendations number 19 and 35, which actually set out the due diligence standard for violence against women. So if you could kindly just unpack for our audience so that they can understand what is the due diligence standard for violence against women, what does it entail, what are the obligations upon the state towards victims of violence against women. And yeah, so you can just talk about the due diligence standard, and you can also make references to the case that we're talking about, the IW case. Dr. Ruth.
Thanks, Winnie. So the due diligence standard is a principle that has emerged in international law and now even domestic law, including Kenya, really as a result of feminist lawyers, but also just feminists generally resisting the way in which the law understood or treated violence against women. And the idea is to say that, traditionally governments or states are held accountable for violations where they are directly imputable. It's a state actor that has done 1, 2, 3, and then they would be held accountable. The state would be held accountable. But the due diligence principle emerged to say that actually, if we look at the context of violence against women, we know that these violations are most likely going to happen at the hands of private actors, and that the state, the law, should have something to say about it in terms of protecting women from violence and preventing it. And so due diligence says that even in instances where it's not necessarily a state actor that has committed a wrong, this is now outside of human rights or even violence against women, that the state can be held accountable where there is a failure to prevent, or to protect, a failure to exercise due diligence in preventing that violation from happening in the first place, or not responding effectively once that violation has happened. And this has gone on to just grow and evolve, through case law, to be unpacked in terms of what's the meaning of this due diligence standard. And in the context of violence against women, we now know through the instruments that Nikki has mentioned, but also through a lot of case law, that the state has an obligation to prevent violence from happening, to protect victims of violence, to investigate effectively, to prosecute and to punish perpetrators of violence, but also to ensure that the remedy that's given to the victim is actually adequate. It's not just a remedy but that it's actually an adequate remedy. And, the interesting thing with this case is that this was a former police officer, right? And now in his personal capacity, he rapes his employee or intern. And when she tries to access justice through reporting to the police, she's frustrated at the investigation process. And there are many cases like this where this is someone who's acting in his individual capacity, and you see a violation there that he has done, but then also the way that the police failed to investigate, amounts to a failure of the state to investigate. There's a decision which this case also refers to, the 160 Girls case, which in Kenya at least defined a very clear standard for what effective investigation should look like. It should be prompt, it should be professional, it should be proper, it should be effective. These are things that really failed in this case. So if we talk about proper investigation, this means it should be an investigation that's properly in line with the law, in line with constitutional imperatives of non-discrimination, of dignity. And just like Atina was saying, this was a failure on all those levels of constitutional human rights standards, that when the police was trying to have her change her witness statement to rewrite that this violation actually happened in this area as opposed to this area, in order to create a situation where it is that police station that would be in charge of watching that whole case and not move it to another police station. That's just unprofessional. It's improper. When she tried to so they say they took her to Nairobi Women's Hospital, for the medical examination and everything, and she left her clothes there. And then the police asked her to go and collect them back. So in this case, in rape cases, it's hard to find, evidence of DNA or things like this usually. And we don't even require it. I mean, the law doesn't require corroboration. But this was one of those cases where actually there could have been evidence that was collected, because she kind of followed that real rape stereotype. She didn't shower, she collected her clothes and she took them there. And then the police asked her to go and take the clothes back, so that she can now come and enter into this agreement together. So you really see a failure of the obligation to investigate here, just because the professionalism is completely missing, the effectiveness is missing. And effectiveness has to do with, can the investigation is it likely to result in justice? You know, there's really no obligation that every rape case should result in a conviction. That's not the standard, but it's whatever the police are doing in investigating, is it effective and putting up the best chance, you know, for the case to result in a just outcome? There's a decision by the African Commission, which was a decision against Egypt by Interrights. And that is a case where the commission considered this issue of, you know, sometimes the police will say there's so many discrepancies in this case and the investigation has become difficult. We really don't know whether we can get to the bottom of this anymore. And the commission said that actually, no, you can't rely on discrepancies to delegitimize a potential case from moving forward, that the police should actually do everything in their power to effectively investigate. Another interesting thing in this case, you know, so the police ask her, there's this issue of whether or not they went to the crime scene. So the police keep insisting that they went to the crime scene. And I kept thinking, so they are saying that the crime scene is a physical place somewhere on the road, which the victim was unable to identify because it was dark at night. And that's the state's response. But this rape happened in the car. So did they actually go and investigate? Because it doesn't seem to be contested that this, whatever happened, actually happened in his car while he was dropping her home. That would be the crime scene for rape is not necessarily always going to be a physical location. It, you know, the woman's body, the victim's body, it could be the location where it happened, in this instance, the car. That's completely overlooked. And just to say that, oh, you know, we drove around with her and we couldn't locate, she couldn't identify where it happened in the night. So these are things that just based on the standards that we have of unpacking what due diligence means, really result in a failure. But one of the questions also I had related to what Honorable Njoki was saying is, so this was a constitutional petition, but the state argues that this case was actually filed as a criminal matter, and they gave some reference there. And I kept wondering, you know, there's so many layers to this as well, that if she wanted to proceed with a criminal matter, that could be one thing. But there's also a very clear sexual harassment reality here, because often with rape cases, they are relational, they happen in relational power dynamics, and this was her boss. So she could also pursue this as a sexual harassment claim, whether within the Sexual Offences Act or within civil law. But there are just so many options, legal options, that she could have been given. And the law requires that police officers in investigating will let the victim know these are the options available to you. But instead of that, they just decide to settle this out of court. So her rights were really violated. And I'm glad that this came forward as a constitutional petition to highlight the failure of the police in that regard. Thanks, Winnie.
Thank you so much, Dr. Ruth. It's always such a pleasure just hearing you talk about the state due diligence obligations for VAW and actually unpacking for us the duty to investigate what does it entail and relating it to this case. Thank you very much about that. So I think let's now talk about the role of the judiciary. But before that, I can see Sibongile. Sibongile's hand is up, so maybe you can
Sorry, just like minor housekeeping, you may have been seeing invites to join as a panelist. We are not ambushing you. We're not going to make you a panelist. We are moving you to the space where we can all see each other, because I think right now you only had 4 things on your screen where you only see the panel but not the other participants. So please accept that. We are not making you a panelist. It's just the way the platform is set up. Thank you. Sorry, Winnie.
It's okay, Sibongile. It's fine. So thanks, Dr. Ruth. I was just ushering us into this session where we can talk about the role of the judiciary in holding the state accountable in its obligations towards victims of violence against women. And I'm going to pose a question to Honorable Njoki Ndung'u, Honorable Judge. Given the prevalence of sexual offenses and sexual violence in Kenya, what is the importance of access to justice through the court system for survivors? And why is it necessary that victims have access to court? Why is it that we are pushing so hard to have victims access courts rather than just telling them to settle the matter out of court?
Thank you for that question. I think that there are several reasons why access to courts is critical for survivors of sexual violence. I think first, the courts formally recognize the harm that is suffered, and they do affirm the survivors' rights under the Kenyan Constitution and international law. So they uphold human dignity and rights. Secondly, courts ensure accountability and deter impunity so that the formal justice system holds perpetrators legally accountable, and hopefully that will prevent future offenses, or it will act as a deterrent. Thirdly, the courts will deliver redress and support, and it's possible for survivors to access remedies such as compensation, protection orders, and even psychosocial support through the courts. And we've done so in the courts, which I'll be talking about shortly. And then without court access, then the survivors' risks of being pressured into traditional or community-based settlements, like we talked about earlier, often results in re-victimization. And therefore, I think that the courts help that way. And apart from enforcing the constitution and legal obligations of the state, I think the courts are able to review state conduct, like this case, for example, and hold state agencies accountable for inaction or even delays in addressing violence against women. And of course, then there's the development of progressive jurisprudence. Through rulings, the courts can expand the protections for women and girls. And I think what we have tried to do now is try and promote a survivor-centered justice. A responsive judiciary, in doing so, will foster public confidence and empower more survivors to seek justice. In Kenya, we have established specialized courts. In fact, there are 13 of them right now. They're known as the SGBV courts. And all those courts do is listen to those cases. So, and the way they are constructed is in a way to give privacy to the victim. The magistrates who are listening to those cases have special training, and they're located in different parts of the country. Of course, we're having challenges right now. Many magistrates say that they cannot listen to those cases for more than a year. We have the issue of burnout. They get depressed. So again, we're trying to figure out how best for these courts to work. So I think I've summarized my thoughts quite well. Thank you.
Thank you so much, Judge. We are so grateful that you're actually here to give us your point of view for sitting on the other side of the bar. So we are really grateful for that. And speaking of a survivor-centered approach, Ms. Tina, I'm coming back to you. What happens in instances where a victim actually prefers an out-of-court settlement and they say, this is what I want? What is the role of the justice system in the protection of such victims of sexual violence?
Thank you, Winnie. And I think a lot of what has been stated by the previous speakers speaks to this, but I'll just add on with a few thoughts. So the first concern which we have been articulating since we began the consultations is, to what extent can we apply alternative dispute resolution to serious offenses, sexual offenses as prohibited under the Sexual Offences Act? And if we're to go by the principle of legality, for instance, for criminal offenses, as a first point of intervention, the principle of legality requires that when that the law would state the offense and provide the specific penalties for those offenses. And therefore, our reading of the Sexual Offences Act in its entirety, in addition to the specific provision provided in Section 40, then would suggest that, and as affirmed by the judgment, that sexual offenses would not be open to out-of-court settlements. And I think just as one of my parting shots in my previous intervention was to say the judgment then provides us the room now to speak to the extent that Article 159(2) or alternative justice mechanisms would be applicable to gender-based violence. Do we begin to talk about gravity and threshold? Is it really applicable in any case concerning gender-based violence? I think sexual violence cases is clear, but to what extent then would it be applicable to other forms of gender-based violence? But having said that, I think a victim-centered approach requires us to then ensure that the survivor's needs and priorities are centered in our approach to implementing the state's due diligence obligations, as Dr. Ruth spoke to earlier. And this therefore requires, first and foremost, that survivors are well informed about the law, what the law then provides in terms of prohibition of the offenses that they have experienced, what the law requires in terms of investigations and prosecutions, and the remedies that would be available to them within the course of justice. But having said that, I think another important aspect for us to consider as we speak to access to justice is how we ensure that survivors have holistic care and response safety, confidentiality, and ensuring that their well-being is protected along the referral pathway. And this is where we come back 360 to policies, resources, and mechanisms that ensure that survivors can report safely, and that after reporting, we have a holistic system that does not only subject them to the choice of having to go through investigations and prosecution, but also provides them with rehabilitation services, psychosocial support, counseling, and so on. And, you know, under our law, the Sexual Offences Act and the guidelines that speak to prevention and response to sexual offences, healthcare is not a precondition for access to justice, neither is access to justice a precondition for healthcare. And so informed consent of survivors, following an appreciation of what is provided in the law and the remedies and interventions that would be available to them, would then provide the room for survivors to determine whether they would want to proceed with prosecution at that particular given time, or if they would want to come back to it at a subsequent time. But another important thing to note within this referral chain is the question around what triggers accountability. In our system, we have the post-rape care form and the P3 form. With regard to the post-care form, it's intertwined. It's a medical legal system that can, in itself, through the evidentiary collection and documentation, can then support survivors to be able to access justice. But how do we then provide support systems that can walk the journey with survivors from the point of disclosure to accessing healthcare and rehabilitation services, and leaving the door open for when and if they're prepared to walk the journey of prosecutions and accountability. And so I think there's also a discussion that this judgment then opens up here. We're not, I believe, and I'll open this to Justice Njoki and my fellow panelists, we're not advocating for mandatory prosecution, even in the absence of survivors' consent, informed consent, to move forward with accountability. But we're advocating that the state must ensure that there are effective mechanisms to support survivors along this pathway towards obtaining access to justice for sexual offenses without the provision or consideration of out-of-court settlements, which have been determined to be unconstitutional, as has been provided in the law and in the judgment. And finally, as I was speaking to this 360-degree support to access to justice, there's also the question that we then must ask ourselves with regard to accessibility, availability, and quality of access to justice. We were speaking about the case in the IW case and how she was duped into changing the jurisdiction of the offense, moving from one jurisdiction to another. This strongly speaks to information and the role of the law enforcement and the justice system in working with survivors through that journey. Other questions that emerge are, for instance, evidentiary threshold. What amounts to evidence that can then trigger access to justice? And this is another barrier that we're continuing to encounter in our justice systems. There is a misnomer that unless you have the vaginal swabs, the DNA test, forensic evidence, that then is when you would have a strong case to pursue. And oftentimes police officers provide a very high threshold or hurdle for survivors to be able to overcome before triggering these cases. So suffice to say, just to conclude, that the justice system's response to survivors must be to ensure that they're well equipped and informed about the provisions of the law, our collective undertaking as a society to prohibit sexual offenses in the Sexual Offences Act, the penalties that are provided therewith, and the support that is available through the access criminal justice system to support them in securing not only rehabilitative services, but also prosecution for the offenses that they may encounter. Yeah, thanks.
Thank you so much, Ms. Tina, for that. And thank you also for bringing up the issue of the evidentiary threshold, because it was quite an interesting point to note. And I don't know that I was speaking to Dr. Ruth or who, and we were just asking each other, like, how practical is it that a victim would actually have the actual out-of-court settlement agreement and produce it in court, considering the circumstances under which these agreements are usually entered into. And another issue that was coming up from this case is the issue of secondary victimization and re-traumatization. Dr. Ruth, perhaps you could just talk to us about this. What are the societal norms in Kenya that encourage the police to treat victims of sexual violence with impunity and trivialize their experiences? And as you're talking about that, maybe you could also give us some examples of the ways in which the investigative processes subject the victims of violence to re-traumatization.
Thanks, Winnie. Yeah, so there are many, social norms around rape or other sexual violence, which, we find they're mostly informed by relational power dynamics. And this is not surprising because statistically, we know that a majority of perpetrators are people we know, even if they're not intimate partners necessarily. In this case, it was a boss. So usually the social norms are often informed by the relational power dynamics that happen in this context, and these are gendered, the power dynamics. And the first one is really that offends me the most, and that is so consistent in many of these cases, is just this idea of men's entitlement to women's bodies in general, and just to feel like women can't say no, but also maybe that they can't change their mind, or they can't walk away, or there's a historian called Kimmel, and he writes about this idea of aggravated entitlement. And, it's this idea of, in society, especially with the gains that we have made. I mean, this is, I think, almost 20 years now since the Sexual Offences Act, if I'm not wrong. And, when we see the wave of rape law reform and all of the progress we've made as women's rights activists, and just the work that feminism has resulted in, the fruit, there's then this backlash that we continue to encounter. And one of the types of backlash is when men or people who are previously in a position of privilege or entitlement begin to feel like equality is now unfair to them. And, it creates this entitlement. I'm sure a lot of you have seen the growing, or maybe if you haven't, we'll share a link of the growing manosphere in Kenya. And a manosphere is just, online, but also offline spaces where outright sexism is played out, but even beyond sexism, which is just, subjugation of women and discrimination of women, just to misogyny, just the hate of women, the controlling of women. And we know often that violence is a tool for controlling, women, especially gender-based violence is used as a weapon to remind women of their subjugated position. And, when you look at this in context of this entitlement to women's bodies, often in a context like this, where there's power dynamics, perhaps this boss could feel, you owe me. I mean, I gave you a job. You're an intern. And in situations where there's power playing out and it's like, I deserve, or I can take whatever I want. So that even if somebody is saying no, sexual violation is just enacted on women, irrespective of whether or not, they actually want this or whether they can complain or not. There's a book by Dee Smythe, which was again on rape law reforms. And the name of the book is Should We Consent? And I've been thinking about this a lot. The name of the book is a question. Do we really believe that women should consent to sex? Or are we just in an era where this is something that can be taken? We've seen a lot of even just the femicide in Kenya is informed by much of this sexism and misogyny and patriarchy that lives within our social norms, where women are killed, women are raped because of entitlement that, boyfriends, lovers, husbands, bosses have on women's bodies. And the problem with this kind of belief system is that it not only produces violence against women, but it justifies it, it explains it away. So even when the police are receiving these complaints, they are part of this society that we live in. They're not, living in a bubble outside of this context. And they can have some of these beliefs which go like, I mean, what was she even doing in her boss's car in the night? So he told her to wait for her. It's at night. Doesn't she know that a good girl doesn't typically hang out with men in the night? So this goes into those stereotypes that we know about what's a real rape, what's accepted by the criminal justice system as a real rape, as opposed to one that's just not real. Like if a woman enacts herself in a certain way, then she's more likely to be believed. And if she acts in another type of way, then she's most likely not going to be believed. There's also this idea of that continues to live on. And, Professor Rashid has done a lot of work during her tenure as a special rapporteur on highlighting the problem with the public and the private false dichotomy, that there is this idea that, violence against women, sexual violence, rape, this is just something that happens in the private sphere. It's not really something that is for state intervention. It's not that serious. And so the police, often when they receive these cases, they trivialize these cases because this is something you can just go and talk about out there. Why do you really have to bring this mess into the legal system, under the purview of the law? So I'm sure when these police were having this discussion and writing that form and signing it, they were probably just saying, do you really want to go through this mess? These cases are difficult to prove anyway. Do you want to put yourself through a situation where you have to go through this? And here's the situation of somebody who actually wants to come forward. This is unlikely. We know this, that statistically, most women will not even want to come forward. But here's a young woman who's saying, I want to go to the legal system. I want to seek justice through the courts. And then she's discouraged on the basis of this belief. So insisting that Tina alluded to this, that there must be physical evidence or DNA in order for this to happen, is a common other manifestation of some of these social norms. And a lot of it comes from also this idea of moralizing women, you holding women to a particular social morality standard that you believe in. And if they diverge or if they're different and they do things differently, then they suffer sexual violence, then they just should not complain. That's their problem. They should find a way to resolve this out of court. They probably should do better next time. And we know many examples of instances like this, and ways in which then victims become re-traumatized in the criminal justice system. First is just that they're not believed. Often from the beginning. And again, we're not saying that women don't lie, that women are angels from heaven. The idea is just that when it comes to sexual violence, there's sort of a default setting where victims are just disbelieved from the beginning, especially if they're young women and it's a situation like this with a boss. We know this idea where it's like, look at the young women of nowadays, they are just looking for sponsors, and now something must have gone wrong, and that's why she's here to complain. So all manner of excuses are given to just not believe the victim as a default setting, as opposed to saying, okay, let's have an open mind and see where this goes and hear the story with the sensitivity that it deserves, given the nature of this type of violation. That doesn't happen often, and that re-traumatizes the victims. And then the real rape stereotype that we've talked about, which is also, again, around the hue and cry, that if she didn't report quickly enough, if she didn't, do all of these right things that she's supposed to do before the rape happened, where was she, how was she dressed, what was she doing during the rape, did she run away, did she cry? If she just went and reported to the boyfriend, why did she go and report only the next day? So there are all of these things around that if you didn't act a certain way, then you are almost, the burden is shifted on the victim for them to try again and again to explain to often multiple sets of people that this was actually my experience. And that alone by itself is very traumatizing. There's also, and the whole point with this is that what the legal system then expects the victim to do is just not based on the reality of how sexual violence happens. And instead of working with experts or trauma counselors to explain to the court why and how this situation that a victim has gone through is may not even be meeting certain basic tick box legal standards like reasonability, which is what an investigation process should do and a prosecution process, instead of saying, this is what we know now scientifically about how rape happens, about how the nature of sexual violence, so that the courts can understand, then we see investigation processes just draw negative inferences. They just draw negative inferences and continue to delegitimize and disqualify the victim's experience. Based on the kinds of questions they ask them, they end up distorting the narrative until the victim themselves start questioning themselves often, and they're like, okay, I actually don't know whether this happened in the way that I think it happened. And this is the main challenge. So then, of course, even eventually when the victim then goes to court, they are so shaken because of how it started, that they're not able to be the best witness they could be. And that then continues just to work against their favor. So I'll stop there for now, Winnie, but just to say that there is so much, in the legal standards and through practice and procedure that we've now learned about how to do this right, that in a case like this was just inexcusable, what the police did. Thanks, Winnie.
Thank you so much, Dr. Ruth, for unpacking for us just those aspects of re-traumatization and secondary victimization of victims of violence against women. I can see the questions that are coming in. So if you have a question, kindly just write it down in the chat box, and then we'll get to it as we're drawing to a close. So Nicolette, the objective of strategic litigation is, of course, to create jurisprudence, but beyond that, we are talking about creating a wider social impact beyond the courtroom. So what are the various legal mobilization strategies that can be used by women's rights organizations and feminists in order to further the jurisprudence that is created in courts, especially in this case? And how do we move the victory that we get in the courtroom? How do we move it to the society in order to make an impactful societal change that we are seeking?
Thanks for that question. And I think the first point I want to make is that the kinds of litigation that is being taken up on the continent to unpack due diligence standards and really unpack what the duty to prevent, investigate, prosecute, and provide remedies, what that looks like, is important. So I don't want to underestimate the importance of the strategic litigation. But I think the Maputo Protocol also speaks about the need for mechanisms and accessible services and information for survivors. How do we make the jurisprudence more accessible to survivors and to a whole of society around what does this mean? What does justice look like? What are these duties to investigate and prosecute and punish? I think we need to open up that conversation to a survivor-centered conversation. What does survivor-centered approaches look like? We need to simplify the judgments, the due diligence standard. Lawyers, we get very excited when we talk about all the conventions and the due diligence standard. But when I try to explain that to my grandmother, it's like, no, people don't understand. What does this mean? And I think we need to be getting feedback. We fought over 25 years for these reforms in international law, national law, sexual offences courts, specialized courts, guidelines for police, guidelines for prosecutors. What are we seeing and hearing around how that's filtering down to the real lives of survivors and in society? Because we're in a moment of backlash where societies are disillusioned with the criminal justice system and want to take the law into their own hands, where you have a backlash against gender, a backlash against survivors. And so there's something happening on the streets. There's some very interesting progressive things happening in the international frameworks, the regional frameworks, and the judgments. But on the streets, what's the conversation? And how do we open up the conversation in a way that's not just about know your rights as survivors, but also hearing from survivors? I sometimes worry when I see mobilization, and I think mass mobilization, public outrage and anger around what's happening around femicide, what's happening around gender-based violence is important, but sometimes it can also revert to the bring back the death penalty. Justice equals bring back the death penalty, castrate rapists. How do we have a conversation around the human rights-based approach to prosecuting, punishing, and providing remedies? And what does those remedies look like in terms of reparations, restitution, compensation, rehabilitation, psychological healing? And what does justice then actually look and feel like? I think that's really important, and clarifying the role of the state, clarifying the role of victims' rights, and having mobilization happen that's informed by a human rights approach and a survivor-centered and a feminist approach to this work, but having the conversations with those that may not necessarily agree with the human rights approach and may be asking for something that looks and feels quite different to what we may be advocating for. I think there's a lot of misconception about the rights of accused people and the rights of survivors, and the backlash around, oh, feminists have taken away all accused rights. I think a proper understanding around this moment is important. And so I would love to see this judgment open up a conversation around what does justice look and feel like? What does a campaign look like that know your rights around due diligence standards, but also hearing from survivors and capturing the fact that survivors aren't monolithic in their approach to this? And how is society responding? Because sometimes you have non-survivors and broader society responding to what justice should look like and feel like. You have vigilante forms of justice, you have different ways of interpreting this, and how people are using the courts or not using the courts. And what we thought was going to happen by changing the way the courts operated, changing the way prosecutions happened, by having progressive laws, we expected something to play out in a different way. If survivors and communities are still disillusioned, what are we going to do about that? And what does our campaigning and mobilization outside of the court look like? I'll stop there.
Thank you so much, Nicolette, for just taking us through that. So I can see the questions coming in. I'm still encouraging the audience. If you have any question that you want to ask the panelists, please feel free to use the chat box or the Q&A section as well. So this last question now goes to all the panelists, and you'll have 2 minutes each to respond. In your opinion, how can women's rights organizations and feminist lawyers use this judgment to pursue a safer world for women? How can women's rights organizations and feminist lawyers use this judgment to pursue a safer world for women. I'll start with Ms. Tina Alai, and then I'll go to Ms. Nicolette, and then Dr. Ruth, and finally Honorable Njoki Ndung'u.
Thank you, Winnie. We've come full circle. I think just to reiterate again that this decision adds on to the jurisprudence that we have already been building within the Kenyan judicial system, but also regionally and internationally, that affirms the state's holistic due diligence obligations in prevention and response to sexual and gender-based violence, and really emphasizing that accountability is one of the critical pillars of the state's due diligence obligations. And so I think moving on from here, there's a need to, just echoing what the other panelists have said, to disseminate the decision further, but to also have further reflections on it. Oftentimes as lawyers, we take a step back and think about perhaps what we could have added, what we could have reframed. How do we build on this jurisprudence to continue to affirm the state's obligations? But the second, which would be worth considering, and here looking more to the policy framework, is how we clearly articulate in specific guidelines or policies this position that sexual offenses are precluded from negotiations or alternative dispute resolutions. And how do we frame that vis-a-vis the principles that are outlined in Article 159 of the Constitution? And this speaks to this balance that we're looking for between unburdening the justice system with the many cases that have clogged the system, but at the same time, really speaking to what is our collective value as a society? What premium have we placed in the prohibition of sexual offenses as criminal offenses in the Sexual Offences Act? And therefore safeguarding those values of prohibition and deterrence of sexual offenses by precluding them from alternative dispute resolution mechanisms. So there's a need for clear articulation of guidelines and policies to that extent. And finally, I think this judgment reminds us of the persisting need to provide a holistic ecosystem that is victim-centered on response to sexual offenses. And when we look at the journey that IW walked, all the way from the point of reporting and what she experienced at the point of reporting, the discrimination along the way, the misleading, misinformation, and all of that, we cannot afford to look at investigations and prosecution of sexual offenses in isolation of the need for ensuring that there is safe reporting, that there is effective addressing of the structural causes of sexual offenses in the first place, the gender-based stereotypes and structural discrimination. It is all of this that will give survivors the confidence to come forward and report the cases and trust that the justice system is going to give them effective remedies in the long run. And so the case is reminding us, and all of us from a multi-sectoral perspective, of the need to persist in providing necessary capacity building, necessary resources, infrastructure that address all these barriers that survivors face along the justice chain, ensure that there is enhanced access to information. I think it would be important, for instance, that the public knows that the judiciary has affirmed that no police officer has the right or entitlement to settle any sexual offenses out of court. We know these are provisions that are already in our laws, but I think this judgment then provides us an opportunity to enhance public education. And finally, I think the case also speaks to the need for an effective monitoring and accountability framework. I wonder if IW's situation would have been different if there was a place, if there was an institution, if there was a hotline, she could actually call and say, this is my experience. This is what I'm now being subject to intervention to deal with cases of interference with access to justice. Why do survivors always have to bear the brunt of filing constitutional petitions that take years in the courtroom? In the case of IW, I think it's encouraging that the case was filed in 2023 and determined, was filed in 2021 and determined by 2023. Post-election violence cases, which we have been dealing with since 2013. And what are we looking for? We're looking for the court to affirm an existing state obligation to prevent and respond to SGBV. And so I think collectively, let's begin to think about mechanisms that can offer timely and effective response to survivors when they face barriers and situations of interference with access to justice, such as this. And that can only go hand in hand with this enhanced public education and awareness that spells out what the law says, what the state's obligations are, and what survivors can access in terms of services and remedies under the law. Thank you.
Thanks, Tina, for that. Colette, 2 minutes.
Since I spoke to this, I think in my previous answer, maybe I should try to answer one of the questions here from Charlene around AI, but posing a risk. What I saw was that in the German context, they've said that in cases of revenge porn, in cases of partners breakup, where people are putting pictures online of women, they have found that the use of alternative dispute resolution to quickly remove items off the internet and provide some form of relief for women where their pictures have been posted on the internet rather than going through court processes has been found through conversations and some research with women that have been subjected to this, saying in cases of revenge porn or pictures being put on the internet, what are the alternatives than waiting a long process for the criminal justice system to run its course? And I thought that was quite interesting because I think, Tina, you raised the point earlier around what about in other types of cases? When do you submit to this? And I think, again, it's important, what do survivors want and need? And survivors may say as quickly as possible, this is ruining my career. I want this dealt with in a speedy way. But can the criminal justice system be speedier? Because the state does have an obligation to investigate, prosecute, and prevent forms of violence. And so I think unpacking this piece in terms of different forms of violence and also how we think about what effectiveness looks like, because the standard has been set around effective investigation, effective prosecution, effective remedies. And so I think that's a piece that's missing. I also think that secondary victimization, all of this, the case in Kenya, for me, it all comes back to forms of secondary victimization when survivors are trying to access justice. And so how do we bring that to the fore in terms of these are your rights? These are your rights as a survivor. And when you're subjected to this, there's a form of accountability under international law and under national laws, and it can be swift and there can be a remedy available. I think the specialized courts are probably best equipped to deal with that. But how do we make that a quick, seamless process that everyone knows about when they're going into a police station already is going to be important. Let me stop there.
Thank you so much, even just for jumping into the next session and answering Charlene. I believe that was a very good answer. I'll go to Dr. Ruth. How can women's rights organizations and feminist lawyers use this judgment to pursue a safer world for women?
Thanks, Winnie. In 2 minutes, I think what I can say is that with the rollout of the alternative justice system in Kenya and the steering committee, This is big. You know, many people who've engaged with this will know that this has been used, the AJS, as an opportunity to reawaken conversations on, can we really not settle GBV cases out of court? Are you sure, you know, that we can't really? So I think for women's rights organizations, now is the time to use this judgment to enter those discussions with real intention. I've put in the link, the website to the steering committee on AJS in Kenya. This is being rolled out and it's very promoted. And I'm not like against AJS in general. I know that one of my toxic traits is I can be a purist and I can just say like completely no GBV for alternative justice system. That's what I incline to. But you know, there's a pushback. I'll say there's a pushback, even though we know what the law says. We know that GBV cases, sexual offenses, have been excluded historically. There is a wave of, and I've sat in meetings where people will say, you know, maybe we can again think about how to do this and rethink the principles of protecting victims through AJS. And the strategy here is again this thinking that there's so much delay in the courts. Are you sure we can't find alternatives? We are African. There's a Pan-African edge there as well. Like, you know, historically, there's a way we used to resolve these things. Are you sure we can't go back and challenge these colonial ways of doing things? And I mean, I've sat with my mom and she's given me stories. She was with me and she's given me stories of how in Maasai culture, for sure, there were ways of like handling rape that were hectic and serious and accountability centered and all of that. But the moment that we are in right now is that I fear that with the rollout of AJS, there's just going to be very nice legal language and that's going to be used again to whitewash this, the same problems that we've had with out-of-court settlements, but just sort of put in a nice suit and made, you know, look very nice and proper. And then, you know, now we are like we're doing accountability the African way. So if you look at this website, the motto really is that AJS is changing the justice narrative in Kenya. That's the motto. And I think for women's rights activists, we have a responsibility to be part of how that narrative is changing and shifting so that we can make sure it's not, you know, going to, you know, bring us back from all these wins that we have that are in statute, that are through this decision. We really don't want to go back to a place where out-of-court settlements is again legitimized by, you know, legal practice. I think that would really be a miss. So thank you, Winnie.
Thanks, Dr. Ruth. And finally, Honorable Njoki Ndung'u, just in 2 minutes.
Yes, thank you very much. First of all, I've just seen a question to me on my opinion about the constitutional petition. And just to say that I just came out from another meeting talking about 3 other different cases. I might have misspoken. I agree with the finding of Justice Murima in this case, and I think it's a good decision. What I really need to see, what I would like to see as one of the drafters of the Constitution and the architect of Sexual Offences Act is we need to see ISLA and other NGOs coming with much more public interest litigation around women's rights. The laws have given, you know, the platform for people to come on public interest litigation on women's rights issues, but we're not seeing that in the courts. And I'm so glad that this case is one of them, but we need to see much more. And, you know, I would encourage you very much to continue to do this work. The fact is, in Kenya and in other countries, we simply have a rape culture. That's what I call it. It was there when I was lobbying for the Sexual Offences Act to be passed, where in fact we had to use to persuade the members of parliament. The face of my lobby was a male doctor, and the victims was an old woman of 86 years old, and her son is the one who came to testify before the male MPs, because if you brought a beautiful young woman, they wouldn't believe it. There's a rape culture around us. It's much worse now, actually, with this manosphere, as Dr. Ruth talked about it, and the rollback on the women's gains and the sexism and the Andrew Tates and the Kenyan Andrew Tates. There is something serious happening. And so long as the socialization is happening in that way, where women are being demeaned and there's so much hatred. The police officers and the judicial officers, they are part of this society. I had to call out the former Chief Justice a few years ago, and he was saying that, oh, the Sexual Offences Act is just being used to jail young men, and young men have filled the prisons. And I had to ask for a platform in which I demystified that. I said, there are no young men in that. He was saying boys, actually. Boys are in prison. I said, there are no boys who are in prisons. Boys who are offenders go to pastoral institutions. But if young men means men between 18 and 25, there are men who have committed murder, 18 to 25, there are so many. They've committed robbery with violence. They've committed acts of terrorism. Nobody is pleading their case. But when it comes to sexual offenses, suddenly there are young men suffering in and languishing in jails. So even men and leaders who are holding top positions, they are part of this culture that wants to simplify, and they're not taking the issue of sexual offenses seriously, particularly against women. They don't, I think half of them don't even believe they can happen against men. So the question is, what are we going to do about this? This is bigger than the judiciary. It's bigger than cases. Of course, we can use this kind of case as part of lobbying, as part of going to tell that very AJS committee. Indeed, Dr. Ruth, they were trying to open up sexual offenses into the AJS, and I was like, it cannot happen. But what do we do about the culture that exists that is allowing the victimization? And then one more point I was going to say. I've been sitting on a lot of appeals, or I can see a lot of appeals coming through the system. You have perpetrators who are jailed, the victims are there at the trials, and then they appeal. The victims are not at the appeals. And we are having more and more judicial officers who are saying, oh, you know, this guy has a family at home, he has served enough time. And in fact, the Supreme Court has had to say that you cannot change the sentences, because now we've been seeing the minimum sentences are now being reviewed by a judicial officer who simply doesn't see what the perpetrator did to the victim. So I think there's a lot more work that needs to go into this area. And I want to really, really thank Isla for leading from the front on this. Thank you.
Thank you so much, Judge. We are so grateful to have you on board again, and just to hear from your experiences. I believe you were answering Caroline Kituku's question. So Caroline, I hope your question has been answered. So we'll just move on to the rest of the questions that have come in. There's a question from Sibongile. She's asking about the draft treaty, which is the Convention on the Elimination of Violence Against Women and Girls. She's asking whether the draft treaty helps to navigate this problem of out-of-court settlement agreements for violence against women. I don't know who is able to take that. If there's any of the panelists who has read this draft convention. Dr. Ruth, you look like you have something to say.
Yes, my apologies. I was just laughing because, you know, before this meeting, I just was holding myself back from talking about the convention because I didn't want to take over your webinar, Winnie. And I know that that was not our focus today, but, you know, in my introduction, I should have said that, you know, I'm in a season of life also where I introduce myself as somebody who's defending the African human rights system and reclaiming, you know, our human rights mechanisms which are being botched. And this convention is one of the ways in which, you know, the African human rights system wants to continue being weakened and to move us back from, I think it was Nikki that really spoke about how robust the Maputo Protocol has been in terms of violence against women, and that if we were to move further, if we were to have a regional convention on violence against women, then it was an opportunity to move us further in terms of strengthening our standards, you know, including now issues like this, moving it into better, you know, normative clarity, but also to strengthen the accountability mechanisms. But unfortunately, this convention has weakened the mechanisms that we have, it's completely a setback and an embarrassment to the continent. And I know that this is not the webinar where we talk about this, but it's really an opportunity that was completely missed. And I can share a link which was shared with me of a panel that considered this convention in the recent African Commission session, and also an article that Professor Rashida and I wrote about, in anticipation of this convention and what we hoped it would have done for the continent, which it didn't do because we don't have time to go into it right now. But to say that the Maputo Protocol remains our most robust standard, which can be used to hold governments accountable. And thankfully now for this decision, we need that in Kenya, at least we can move forward with this legal standard. But I don't know how we'll navigate the current convention because it's no.
Okay, thanks, Dr. Ruth, for responding to that. Our next question is from Wangoi Gitahi from Amnesty International. Thank you for the insightful discussion. My question is, out-of-court settlements take place at the police station in Garissa, where GBV is quite common within the refugee camps. There is a form of traditional ADR system called Maslaha, where police officers sit in the baraza and are given a cut from the payout. As a solution, would prosecuting the OCS and OCPDs of these police stations responsible work as deterrence for this? And she's saying this is similar to police brutality cases where command responsibility is being invoked in the case of Baby Pendo. I don't know who would be able to take that. Just feel free to take it up if you can.
I was trying to find the provision under the Sexual Offences Act. I don't know whether it's under this act or the Victim Protection Act. There is a provision that gives the basis to pursue accountability against individuals who interfere with the process of access to justice. I believe there's a reference under the Sexual Offences Act and the Victim Protection Act. I think we can look that up. So that is already a direct premise. And in fact, I think it does spell out a specific sentence or conviction. And I'll look that up by the time we finish. But if my memory serves me right, and the other panelists can speak to it as well. And I would say, why not? I think the challenge that Justice Njoki is placing at our feet is let's do more. A judgment or petition such as this is chipping away at the problem. And what we're doing with cases such as Baby Pendo, of which Utuwetu is one of the systemic problem. It's not just merely about the 4 officers who are facing charges before the court. The case is speaking to a systematic pattern, this deep-rooted rape culture that Justin Njoki was just speaking about earlier. And the way we get at it is by pursuing accountability that deters those who are interfering with the process that is laid out in the law. So I think a straight answer would be yes, it's possible. We will find the provisions in the law. I cited the Sexual Offences and the Victim Protection Act that speaks about interference with access to justice, and that would provide a premise for this kind of accountability. And more cases, I would say, that seek accountability against police officers and other individuals who interfere with access to justice. Yeah. Thanks.
Thank you so much, Tina, for that response. Wangoi, I hope you have been answered. We have Professor Rashida Manjo, who is saying thanks to the panelists for their great presentations. Unpacking progressive judgment serves an important educative purpose. And she's also asking a question. Will this judgment have an impact on domestic violence cases in Kenya? Or will the public-private dichotomy continue to dictate how domestic violence cases are dealt with? I don't know, Dr. Ruth, you want to take that up?
Yes, I think just to confirm, thank you, Honorable Njoki, for letting us know that this was almost a sinister back route, that was the intention, partly behind the AJS policy and the steering committee and all of that. So I think that it's a real risk. In fact, if you read the policy and the reports that inform the policy, a lot of the examples from different counties is how domestic violence cases were being used as through out of court settlement. And it doesn't disavow completely. It just sort of says, these are examples of instances where maybe perhaps because a lot of the people in the committee were men, then maybe it will be unfair towards women. But, you really do see that it is possible that this is an avenue that will be used. And again, that's why having this judgment now, we need, 2024 decision to say that again, this is a reiteration of the legal position that we know that out of court settlements are not constitutional.
Could I just add to that? I think this is important, that maybe this is the next case we need to be looking at. In a regional context, I think how domestic violence gets dealt with when this mechanism is being used, because this judgment does open up a space where it talks about investigations being free of coercion and not manipulating the justice system. If we extrapolate some of those principles, that you're not manipulating the system, it's free of coercion, you can't abdicate your duties, it must be prompt, it must be effective. And what does an effective remedy look like in a domestic violence case? But I think bringing these cases and really unpacking and getting some of those principles around secondary victimization and coercion and power, how coercion and power plays out in these processes, and in alternative dispute resolution processes, because I think this public-private divide is going to come up, and it would be good to bring a case that looks at the public-private divide, where you don't have where people aren't really resorting to the criminal justice system. What does that mean in terms of women's rights and requirements around taking into account how women feel and how women want to address an issue? So that would be a very interesting case to build on some of the principles that the case in Kenya has already laid out, and to look at other jurisdictions on the continent, because I do think this practice it's coming up in many, many jurisdictions.
Thanks so much for that, Dr. Ruth, as well as Nicolette, for answering Professor Rashida's question. I can see a comment from Sibongile saying that we'll have a webinar on the Convention of Elimination of Violence Against Women and Girls. So watch this space. Professor Rashida also commenting regarding what Dr. Ruth was talking about. Accountability, the African way, must be underpinned by respect, dignity, equality, non-discrimination, and challenging of impunity. Thanks, Dr. Ruth. The privatization of accountability for harms that affect women is not acceptable. I can see Acheng has a question also to the panelists, talking about NCAD and GBV Femicide Task Force are amending the Sexual Offences Act. So are there any sections that the panelists need to be included to further protect survivors? So I don't know, to the panelists, Dr. Ruth, Christine.
Can I say something?
Yes.
I've been in a lot of discussions around the amendment of the Sexual Offences Act. But one of the things that I won, because I was a member of parliament, you may take a small amendment on a section and parliament decides to open up the whole act and take away whatever rights that we had already given. So one needs to be very, very careful when walking into terms of amending. I think one of the things I've encouraged is saying, the issues that are of concern, can they come through rules of procedure, through subsidiary legislation? So you're not touching the Parent Act. But so I just wanted to say that even as we think we want to perfect the act, already negotiating the act to where it got to was very difficult. But especially now that we have this rollback on gains on women, is this the time we want to open up the act in a parliament full of misogynists? Question mark. So that's just, as we're thinking around what amendments we want to make, I think we need to be careful. Thank you.
Thank you, Honorable Judge, for that. That's offering us guidance as the feminist movement in Kenya. Is that the direction that we want to take? I don't know that there's any other comment regarding that from the panelists. Okay, seems like there's none. I can see a comment from Joy. I think she's just supporting what Christina Lai was talking about, referring us to Section 37 of the Sexual Offences Act. I think, Christine, that is what you are referring to. Okay, I don't think there are any other questions. So I'm just trying to see whether there are any other questions that I've missed out on, but I can't see any. So on behalf of ISLA, I want to thank each of our panelists for taking time to honor our invitation and taking part in this conversation on the state due diligence obligation to protect women from violence against women. I can see there's a hand from Honorable Judge. You can go ahead.
Sorry, it was an error. Sorry.
Okay, it's fine. So we have been talking about coercion by state actors to victims to enter into out-of-court settlement agreements with their abusers. I would just want to invite the panelists to give their closing remarks, if any, just 1 minute each, if you have any closing remarks. And then now we can close. I'll start with you, Nicolette. Do you have any closing remarks?
I'd just like to thank Isla for having this conversation. I think we need to be having more conversations like this. And I think the anti-gender movement and the anti-rights movement are using protectionist frames, are organizing to roll back a lot of our progressive legislation, and are organizing around litigation as well. And I think us organizing and strategizing to counter that is really important, because often the language of women's rights and protectionist language is being used in ways that are actually anti-gender.
Thanks, Nicolette. Tina, do you have anything, any closing remarks?
Just to once again thank Isla for organizing this reflection and to encourage us to disseminate to the public. Let's speak with the people and empower them with the decisions that are coming from the judiciary that give effect to the law, so that we can continue to chip away at this humongous challenge of discrimination and the rape culture that we've spoken about. But just to say thank you for having us to be part of this conversation, and we look forward to subsequent reflections. Thanks.
Thanks, Tina. Dr. Ruth?
Thank you, Isla. Thank you. Congratulations on this decision. Congratulations, Winnie. I'm so glad that this went through, and it's another positive feminist jurisprudence. So well done. And I just proudly associate with Isla. Thanks for having me.
Thanks, Dr. Ruth, as always. You've been such a great support to me, to Isla generally. And finally, Honorable Judge, any closing remarks?
Just to thank you for holding this webinar. I really want to encourage you to continue coming to court and to continue holding these feminist spaces. When I was a young activist, we engaged so much, and I haven't seen much of this. So I'm very encouraged, and I think, I will support you in any of your endeavors which are similar to this. Thank you.
Thank you, Honorable Judge. It's been such a pleasure having you and also the rest of the panelists on board. Just hearing from you, gaining wisdom from you. It's been such an enriching conversation. So thank you to each and every one of you. Thank you also to the audience, every person who has contributed. You have contributed by listening, by asking questions. We are grateful. And We have now come to the end of our webinar, but of course not the end of this conversation on the due diligence obligations of the state to victims of violence against women. We hope that this webinar will spur further conversations in our communities and that it will generate and change the narrative on state obligations for VAW in the continent. With that, have a good afternoon. And thank you.
Thank you.
Thank you.
Thank you.